Welcome back to the county seat. Our topic today is talking about the loopholes in the laws that govern mental competency within the state and how long you can hold somebody in a forensic mode. I've just learned that actually just a couple of minutes ago. Our guest today on the panel will be Ron Gordon from the Utah Commission on Criminal and Juvenile Justice, or CCJJ as we will call it from this point on. Brad Daw, who is a representative in the legislature from the Orem area, is that correct?
That's correct.
And of course, Adam Trupp, the General Counsel for the Utah Association of Counties. Gentlemen, thank you for joining us today.
Thank you for having me.
Okay, who wants to weigh in first on this?
Well, I guess I can jump in and give you a little bit of background if that's okay. I heard about this probably about the same time as everybody else did when it hit the newspapers that we were letting a child rapist walk. And of course, the newspapers give you the headline but don't give you really the backstory behind it. I had a member of the Utah County Prosecutors contact me. We had worked together on other issues and said we need to change the law and we need to address this as best we can. So I met with him, Craig Johnson, and we had a discussion, and out of that, kind of the first preliminary cut was the way the law is defined now is what allowed him to walk. It defines a physical harm in such a way that it doesn't include or can include sexual assault, which of course it should. Since that time, Ron Gordon over at CCJJ has been good enough, as well as Adam Trupp, to help pull together a number of people, and we've had some interesting discussions about exactly what's involved in changing the law, how we want to craft it in such a way that it will definitely take care of the loophole that we saw in the case of Lonnie Johnson.
Are any of you concerned about overcorrecting the law? Because sometimes that tends to happen. You know, it's like, you know, some headline and then there's outrage and then they pass some, you know, the legislature gets a lot, and I'm not picking on you by any means, but you get all this pressure from constituencies, we've got to do something, and then this fervor takes over and you have too much law.
We were.
Yeah.
That's
Absolutely.
why we initially called Representative Daw. I contacted him after reading the reports in the newspapers and seeing them on the media and asked him if he'd be willing to work with us. He had some additional background that I did not have. He has the expertise in the political realm that I certainly do not have. We have a statutory mandate to recommend policy to the legislature, to the governor, to the judiciary, and our approach is to, one, ask ourselves, is there a problem? Is there a loophole that we need to close? Mm-hmm. That's the first question that always has to be asked. In this case, I think we all agree that yes, there is a problem. But I just want to make it clear that we did start with that question because the reactionary response is to assume that there's a problem based on a given fact scenario and then move forward and not really have had the discussion about what the problem is and whether there is a problem.
Well, prior to this discussion starting, we did have a brief discussion, and you said one of the problems that the general public has is when they think of civil commitments, they automatically think state hospital, and that's really not where most of the burden is born. Would you agree with that?
That's absolutely right. I think your question about doing too much is really a key from our perspective. The counties provide mental health treatment, substance abuse treatment also, but mental health treatment services for a huge number of people who are not a risk to themselves or to others who have a need for treatment. And the issue really has to be, how broad are we going to cast this net? How are we going to catch these people? And even when you do ask that question, you then have to ask, so what's our response? They're not all going to be in a forensic bed at the state hospital or even in a civil commitment bed at the state hospital. The majority of those people are going to be in the community having been stabilized somewhere and then placed into a different lower level of treatment to help them to get the services they need. So that was one of our earlier discussions, was even if we do broaden this definition and close this loophole, what are the ramifications as far as treatment?
It could be, I mean, if it's too broad, it could be a financial burden on the counties, wouldn't it, possibly?
It could, and it could be a limitation on the rights of some people who really are not much of a risk to others. I think we all, certainly at our meeting, agreed that the Johnson case is something that we're all very concerned about and don't want to see happen again. But the next case is the one that we have to worry about. How do we address that, and what are the factors that we have to continue?
That's part of what your commission is about, is making sure that you're not reactive but remedial.
Yes, I think that's a fair way to state it, to make sure that we're not just reacting to a specific fact scenario, but saying what's the best policy going forward. And so we'll use things that have happened in the past to be instructive, to help us identify the problems. But then, as Adam was saying, we have to make policy going forward. We have to try to anticipate what the next case might be. And that causes us to stand back, to analyze the situation, to make sure that we're not being too narrow in our focus. It causes us to make sure that we are balancing the needs of the public to feel safe, to be protected from people who are dangerous, and to protect the rights of every single person, including us. I mean, we all benefit from the protections that are in the Constitution and in our statutory system.
Very, very true point. Brad, let me ask you a question. As constituents have approached you about this, or the public in general, is there a misunderstanding of competency in trial?
I think that's probably a pretty common thing. The fact is what a lot of people think of as competency is different than the way it's defined in the law. In the law, you have to be able to understand the charges being brought against you, and you have to be able to understand and participate in your defense. That doesn't necessarily equate with what most people think of as competency. And so there is that concern. I haven't really been approached by the public often on that. They're more concerned with the fact that a person with Lonnie Johnson's background has been basically released to the general public. And so if I can communicate to them, well, here are the circumstances behind it, and here's what we're trying to do. And frankly, I want to express my thanks to CCJJ because they've been able to help me understand that as well. I mean, the fact is, my profession really has nothing to do with criminal law or anything like that. That's something I've had to learn as a legislator. It's been a real opportunity for me. And what CCJJ has done is put together a group, including the counties, who would bear some financial costs for this, people from the mental health arena, people from the prosecutor's office, people from the defense counsel, so that when we come together we can craft a law that is proper, that does address this loophole without being either too narrow or too broad.
What's the biggest fear in going forward? I mean, any of you, if this gets to the legislature and you pull us in a special session or general session, what's your biggest fear?
You know, I think that my biggest concern is that we overreact, that this becomes some sort of a frenzy, that we're not doing enough, we're doing too much, we'll get people in there with emotional stories one way or the other. I don't think that will happen, but I'd have to say that's probably my chiefest concern.
I'd say my concern, and I think the concern of most on our working group, is that we end up in the exact opposite position we're in right now. Right now we're in a position where many people agree that somebody probably should have been civilly committed, but the standards did not allow for it. The statutory framework did not allow for it. So what's the scary thing? The scary thing is that we changed the law so much that we end up in a situation where now we're thinking somebody was just civilly committed who we don't think should have been civilly committed, and that's why we approach this cautiously.
Could this problem have been solved if Lonnie Johnson's family had just, could they have committed him after he was released?
No, they could not have. The problem was he didn't meet the definition for being held against his will in a civil commitment, and that's essentially what that commitment is. So no, it wasn't an option to do that. It's in fact simply an open door for people who say, no, I'm not competent to participate in my defense, therefore I can't be criminally prosecuted, and I don't want to stay here, so I want to leave.
So, but that's based on state law. Now,
it's based on both state law and precedent from the Supreme Court of the United States.
Okay, but if he were to cross the lines into another state, say, I mean, I don't know what the laws are, but very possibly he could go into Idaho, and in Idaho, that loophole may not be in the law, and if he committed an act there, but they couldn't catch him on what they'd held him here, he'd have to recommit an act, right? But another law may be at a place where he would be held.
You know, that's a good observation. In fact, we've had legislative research as part of crafting this bill look at laws in other states. And there's quite a variety out there. And what that tells me is this is a difficult issue and one that needs to be addressed properly. And in other states, they have stiffer penalties, and in some they have tighter and looser definitions. So it is something that is certainly a part of what we need to look at, is what other states are doing.
I think one of the things we have to remember, too, about Utah is we're with civil commitment procedures, you're actually trying to take care of individuals who can't care for themselves or who are a risk to others. That's a different goal, really, than our criminal justice system, and that's the struggle we have with changing
And
this
that leads to
legislation.
another perhaps misunderstanding among the general public, and that is the difference between competency to proceed and standards for civil commitment. They're different.
And we've had so much fun in this conversation that I've completely ignored the clock. We've got to take a commercial break. We'll be right back. We'll wrap up with the county seat.
Native Americans called it the land of the sleeping rainbow. It's a place of unparalleled enchantment where history, splendor, and industry meet. We call it Sevier County. Experience the Paiute Trail by ATV. Explore 7 national parks, all within a few hours' drive. Gaze down at the world from an entirely new perspective. Join us in Sevier County and discover real Utah. Come, explore the Paiute Trail and beyond.
Discover your own treasures in King County.
Have you gone on an adventure lately? Have you explored the world? Have you really seen Utah? Join AYL at your leisure each week and see your backyard like never before. Hosts Chad Booth, Malia Bascom, Stephen Heumann, and Reagan Ledbetter open up the outdoors like never before. Catch up with adventure on AYL, Saturday nights at 11, Sunday mornings at 9 on ABC4.
St. George, Utah was recently named TripAdvisor's #1 travel hotspot, and travelers picked Zion National Park as the best national park. If you haven't planned your St. George or Zion getaway yet, visit atozion.com and find out why everyone else is already packing.
Won't you come and play?
St. George, Utah, everything from A to Zion.